duration of the program is 2 years and maximum duration of the program is 4 years. The medium of instruction is English. The program has 4 semesters with a total of 72 credits. We have 17 core courses and 3 elective courses. The program has 2 admission cycles, July and January cycle. The registration is annual. The term and examination will be held after 1 year of your admission and every 6 months thereafter. The course material will be a blend of self-learning materials and open educational resources. The SLM or the course materials will be available for download on eGyan course and in print form. Now the eligibility criteria for the program are graduate with major or honors in physics, graduate with BSc degree including IGNOU BSc with physics and mathematics, graduate with a BSc degree of IGNOU or any recognized open university with a minimum of 32 credits of physics and mathematics as one of the subject. So if you are a science graduate who want to pursue a master's degree in physics and aspire to be a physics teacher at the high school, college or university level, if you aspire to be a researcher in frontier areas in physics leading to a PhD in physics or as a scientist in national laboratories or industry, if you want to attain professional growth through higher education, then this program is an excellent opportunity for you. For more information, you may write to us at mscph@ignou.ac.in or call us at the given number. Thank you and best wishes.
Are you a fresh graduate? Do you want to fulfill your educational aspiration by pursuing higher education in various interdisciplinary and multidisciplinary areas like environmental science,
Hello and welcome to this program of School of Law. Today's topic is related to our Diploma in Paralegal Practice program, that is DIPP, and the course code is BLE001, and the topic is Rule of Law. So when we say rule of law, there can be different meanings depending upon the concept of law which is in your mind. Some may say that rule of law means rule according to law. That is rule, that is the law which is passed by the parliament or the state legislature has to be obeyed. But the broader meaning of rule of law, as far as it in Indian context is concerned, it means rule of law is, the rule of law is not the rule according to law always, because the law has also to be tested on certain touchstones. The most important of them is the Constitution. If the law is not in conformity of the Constitution, mainly the fundamental rights enshrined in enshrined in Part 3, in Chapter 3 of the Constitution, Part 3 of the Constitution, then even if the law is validly passed, it may not be treated as good law, and the compliance of that law may not be treated as the rule of law. So when we say the rule of law, it signifies that the rule should conform to certain principles. And our Constitution has the fundamental rights. There are 6 fundamental rights, and there are a number of things which are implicit in the fundamental rights, apart from the express provision which you can see, the 6 fundamental rights: right to equality, freedom, etc. For example, the principles of natural justice is implicit in Article 14 of the Constitution. Natural justice means that the party should be heard before any decision is taken, and no one should be the judge in his own cause. So the most important, when we talk about the rule of law, the most important concept, the most important, you can say, the prominent proponent of the rule of law doctrine is DIPP, and the DIPP on the rule of law, DIPP, there are certain things, certain requirements for the rule of law. First is the absence of arbitrary power. Second is the equality before law, and third is the supremacy of the law. So these are the 3 main requirements for a rule of law: supremacy of the law, in our context supremacy of the Constitution, and the absence of arbitrary power, and equality before law. So we will explain each of the concepts one by one. So in this slide you can see the absence of power, which is as per the DIPP, arbitrary power shall not be conferred on any officer. Arbitrariness denotes unreasonableness and is against all norms of law and justice. These officers have to carry out the law made by the Parliament and should not exercise any more power. This is the because you see, Dicey was a English jurist, and in England there is no distinction between constitutional law and ordinary law as far as their passage and their effect on the system is concerned, because every law has the same procedure, unlike India, where there is a different procedure for amending the constitution. Some of the provisions can be passed with simple majority. Some of the provisions can be amended by 2/3 majority of each house of the Parliament, and for some other provisions, the concurrence of the half of the states is necessary. So this is the position in India, but in England, Parliament has the power to legislate. So Dicey says that the law, there should not be any kind of arbitrariness, and the officers should conform to the powers conferred to them by the Parliament. Here we can say that for the efficient discharge of the duty, certain discretion is given to the officers, to the administrative officers. They have to decide based on the facts, keeping in view the objective of the act. But these discretions should not be, there is no such thing as unfettered discretion. Discretion has to be exercised in conformity with certain principles. And main thing to be noted, to be kept in mind in this connection is that the objective of the legislation should always be in mind while exercising the discretionary power. So the another aspect is the equality before law, and Dicey says that the rule of law not only means that every person is that no person is above the law, but also that everyone is irrespective of his, her rank or status, is subjected to the ordinary law and to the jurisdiction of ordinary courts. It means universal subjection, means that every law administered by ordinary court. So this is the from the Prime Minister to an ordinary person, everyone should be equally treated and should be subjected to subjected to same laws and courts. Here we can say that reasonable classification can be made. Different laws can be made for different groups depending upon their special circumstances, and especially for what we call affirmative action, or to ensure substantive equality, the special legislation can be made in favor of the socially and educationally disadvantaged groups of the society, which is the case in India. You can see our constitutions, there are specific provisions and there are special laws to deal with different groups of society. So the supremacy of the law, this is the second requirement of the rule of law according to Dicey. The general principles of British constitutional law, which is unwritten are developed by the decision of the courts, especially in individual rights, as these rights are recognized by the courts and subsequently got constitutional status. DIPP viewed them as supreme and having higher protection. So there are certain principles, principles of natural justice, we can say, and in our Indian context, we can say that the law, our constitutional law, and the principles of natural justice, and in some cases the natural law which is, I mean, there has been a debate of positivism and naturalism. The law has to conform with certain higher norms. So the other is the absence of arbitrary power, and the constitution. In our constitution, we can say that right to equality, which is enshrined in Article 14 of the Constitution. The articles say that no person shall be denied equality before law and equal protection of laws. And I mentioned that reasonable classification can be made in favor of different groups. And after A.K. Royappa case, the non-arbitrariness principles have also been incorporated and has also been made part of our constitutional jurisprudence. So Article 21 talks about the freedom, liberty, of right to life and personal liberty, and the way courts have interpreted these provisions. The right to life does not include only animal existence or just by living. Right to life includes right to health, right to education, right to food, right to clothing. Right to life means a dignified living, clean environment, etc. So the way court have interpreted our constitution, our Article 14 is very important to be considered in this connection. Now, another equality before law and our constitution. I mentioned Article 14 of the Constitution, and the preamble of the Constitution also secures equality of status and opportunity. Article 14 to 18 talks about the right to equality, right to use any public places, bath, tanks, ghats, etc. without discrimination, equality of opportunity of public employment, abolition of untouchability, and abolition of title. Only those titles are protected which are based on the merit. So these are the provisions which are provided in our Constitution with regard to right to equality. And with regard to supremacy of the law, in our Constitution, Article 13 expressly provides for just judicial review over the legislation passed by the Parliament or the legislature. On an Article 32 confers the writ jurisdiction on the Supreme Court. Article 13 mainly says that any law which is inconsistent with the provisions of the fundamental right is void. And Article 32, if fundamental rights enshrined in Part 3rd of the Constitution, 6 fundamental rights which I mentioned, right to equality, right to freedom, right against exploitation, religious freedom, minority rights. And if these rights are violated, the person can directly go to the Supreme Court, and the Supreme Court can pass necessary necessary directions in the form of writ. There are mainly 5 writs: habeas corpus, mandamus, prohibition, quo warranto, and certiorari. So, in some other program we will explain these writs, but here it is suffice to say that it is the High Court also can pass writs under Article 226, but the scope of the High Court is wider. It can pass, it can exercise writ jurisdiction in other cases also where there is no violation of fundamental rights. But as far as fundamental rights are concerned, the Supreme Court is concerned, the fundamental rights can be, if the fundamental rights are violated, then the person can approach the Supreme Court. And in recent times, we have seen that the Supreme Court has relaxed the locus standi rule. Person who can approach the court, person who has, even the person has no, not directly affected, is a public spirited person or the public organization can approach the Supreme Court in case of violation of fundamental rights. And in the form of public interest litigation, any citizen can approach the court, and there is no requirement of formal filing of writ petition. Even the Supreme Court has entertained even the postcards sent to the judges where they found that the fundamental rights have been violated. They have and there are also examples where the court have taken suo moto to cognizance of the violation of fundamental rights. So, when we say talk about the human rights, about the rule of law, another important development which has taken place during the last 50 years or so is the development in the field of human rights. Now, human rights are also considered inalienable, and the Supreme Court has, in a number of cases, has held that where the international treaties and conventions are in conformity with the law passed by the Parliament. In other words, we can say if the law of the country is in conformity with the international conventions and treaties of human rights, then even if there is no enabling legislation in the country, the treaties and conventions shall be treated as part of the law, and the court can issue directions if the fundamental rights in the human rights are violated. Another development which has taken place during this 3 or 4 decades is the environment jurisprudence, and it is also clean environment and healthy environment is considered as the part of human rights. If the environment is, if the person has to live in unhealthy environment, it is considered as the violation of human rights and fundamental rights. So, in these cases, these are also when we interpret our fundamental rights, the developments in the field of human rights, environment, and other areas has to be taken into consideration, because fundamental rights are not as in one of the cases, the Supreme Court said these are not empty vessels, and every generation pours into it some new things, some new concepts, some new ideas, depending upon the need of the hour. So these are the new developments which have taken place. And in one of the cases recently, the Supreme Court has said that the court should not follow the originalistic interpretation of the Constitution. The Constitution, when it was formed, because Constitution is a living document, and new challenges or new developments which takes place in the country, in the society, has to be taken care of while interpreting the Constitution. And as our present Chief Justice has said in one of his speeches, that the judges should be aware of the people's problem. Knowing the law is a different thing, and everybody has to be well versed in law, in the nitty-gritties of law. But when we interpret our Constitution, the problems faced by the people has to be taken care of, and the law should be interpreted in such a manner that the people's problem are addressed, and people's rights are, people's dignity, people's rights are protected. So with this, we end our today's presentation. Hope you have enjoyed it. Thank you very much.